Hi, this is James Johnston with 60 Minutes. Today we'll be examining the case of 17-year-old Aaron Figgleman, who attended St. Alamo Senior High School in St. Alamo, Texas. Previously, at the age of 16, he had been convicted of a Class B offense for possession of less than 2 ounces of marijuana. He was suspended from school after the incident. On the morning of April 20th, a day colloquially known as 420, celebration of illegal marijuana use, he tweeted from a public account and he tweeted from his personal phone, "Best holiday of the year, about to get fried and miss Redacted's class, HMU." HMU, of course, is a popular abbreviation for Hit Me Up. The school official, who later admitted to be monitoring Mr. Figgleman's personal social networking accounts, knew about Mr. Figgleman's troubling past and reported Mr. Figgleman to the police. The police came to the school and searched Mr. Figgleman due to a fear that he would cause a disturbance. Prior to the search, Mr. Figgleman was read his Miranda rights, and the police found an ounce of marijuana on his person, and he was subsequently charged and later found guilty of a Class B misdemeanor, and now is suspended indefinitely until his expulsion before the school board, as per school board policy. The student, citing a lack of a search warrant from the police who searched him, has sued the state of Texas. The case has now reached the Supreme Court. Today we'll be hearing from multiple constitutional experts as well as the lawyers of Mr. Figgleman and the state of Texas regarding the case.
What we have here in this case are three basic questions concerning the Fourth Amendment. First, does an unsubstantiated claim that evidence may be destroyed justify an invocation of the exigent circumstances doctrine? Second, how minor of a disturbance in a public place can a disturbance be to be considered a jeopardization of public safety? Third, can a statement on a social networking site professing intent to commit a crime constitute probable cause?
Just look at the constitutional precedent. In Mapp v. Ohio, the Supreme Court established that any evidence obtained through unlawful search and seizure, that is, a search without a warrant, is not held admissible in court. The police who searched Mr. Figgleman did not have a warrant and therefore cannot use any evidence obtained in court against him. It is completely unfair, and we think the Supreme Court will see our side in this matter.
Mr. Reeder just mentioned the Mapp v. Ohio case in relation to his client's case. This case is notable for creating what is now known as the exclusionary rule, which prevents evidence from unwarranted searches from being admissible in court. Mapp's house was searched for evidence, and the police incidentally found obscene materials, which were presented in court as evidence as wrongdoing. The Supreme Court ruled that the evidence should not have been allowed, forming the basis of the exclusionary rule. This does present an argument for Mr. Figgleman's side, as there was no warrant for the search of his person. Within the context of this precedent, that logic is valid, and the marijuana found on Mr. Figgleman's person should not have been admissible as evidence in court. This would change, however, if the police believed they were operating under the exigency circumstances exemption to the Fourth Amendment requirement for a search warrant. In that case, we would distinguish from Mapp v. Ohio.
Good.
In your brief, you argued that not only should the marijuana that was found on your client not have been permissible in court, but that the search shouldn't have been allowed in the first place. Can you explain why you believe that?
Well, mainly when people argue that the search should have been allowed because on school premises, they're basing it on the New Jersey versus TLO decision, when they ruled the faculty can search people on the basis of reasonable cause because of the school environment. However, there is you can clearly distinguish between this case and our case, because in our case, they brought the police in to perform the search. In police searches, they need probable cause, and we firmly do not believe that the tweet constitutes probable cause. By bringing in the police, the school made a warrant necessary for the search and gave up their right to follow the reasonable cause doctrine.
In the case of TLO versus New Jersey, a clear precedent was set establishing that a school only has a reasonable cause to search a student on the school grounds, as opposed to probable cause, which goes for the general public. TLO was accused by another student of smoking marijuana in the bathroom and was searched by the school principal. She was suspended when she was found with drug paraphernalia. The school's primary mandate is to protect its students and therefore is not subject to the same rules that the police would in the public. Applying the precedent to this case, we can see that the school and the police acted within their rights. They had reasonable cause to suspect Figelman and therefore had the right to search him.
Now, an interesting case to look at for precedent here is Kylo versus the United States. In this case, the court ruled in favor of Kylo after the police used evidence gained from thermal imaging equipment as cause for a search warrant to find marijuana. This case therefore set a precedent that the police cannot use special equipment to monitor an individual without cause, and that any such monitoring cannot be used as justification for a warrant. Figelman argued that this precedent should have prohibited the police from monitoring his tweets, which he published on his own personal device. In this case, however, Figelman's tweets are published to a public domain that the administration had access to without the use of specialized equipment. An informed Supreme Court will probably be expected to distinguish between Kylo and Figelman based on the public nature of his tweets.
Another key case to look at here is King versus Kentucky. In this case, the police knocked on the door of King's residence while pursuing a fleeing suspect, heard suspicious noises, and entered his residence. They found drugs and drug-related items and arrested King. The Supreme Court ruled that the police had the right to arrest King, even though the evidence was obtained without a warrant, because they had gone back to a judge to obtain a warrant. Because had they gone back to a judge to obtain a warrant, King may very well have destroyed the evidence. This is what is called an exigent circumstance. Had the officers in Figelman's case waited for a judge to approve a warrant, the evidence that Figelman possessed may very well have been destroyed. This justifies the police and school actions, since in Figelman's case, he very well may have destroyed the marijuana as well, and the police had cause to believe that he would do so.
The last case we're asking the Supreme Court to look at is Potawatomi versus Earls. Now, this case dealt with the school's authority concerning drugs and mandating drug tests in order to participate in extracurricular activities. The court ruled in favor of the schools and established the school's authority to take extreme measures in circumstances involving the health and the order of their institution due to drug use. Applying this precedent to Figelman now questions whether his one tweet about smoking marijuana was really enough to pose a threat to the school. And one clear thing that we're looking at as the state of Texas is his use of HMU, or hit me up. He's offering to share with other students through this, and therefore he would cause a disruption that would hurt the school and hurt the institution and put other students' safety in danger, which would clearly be enough rationale for the police to search him in the school to request that search. As you can see, there are many varying opinions on this particular case. The way that this particular case pans out could change our country's interpretation of the Fourth Amendment, one of the amendments in the Bill of Rights. The Supreme Court is set to hear the case tomorrow, and stay tuned for more news on how this shakes out. We hope that you'll tune in next week for our thorough examination of the failing mental health system in our country. Thank you.